It was raining when the two defendants, their families, and 3 attorneys arrived at Surry County Circuit Court for today's trial. The attorneys were prepared to argue that their clients damaged fuel rods at the Surry nuclear plant out of moral necessity, to draw attention to what they call serious health and safety hazards there. But in pretrial motions in the chambers of Circuit Court Judge Ligon Jones, the defense was overruled. Judge Jones told the attorneys he would not allow them to present evidence that the action was done out of moral necessity or self-defense to the jury. When the trial returned to the courtroom, Judge Jones began questioning prospective jurors. Almost all of the 54 questioned had read or heard about the alleged sabotage, and about half of those were excused because they said they'd already formed an opinion in the case. Afterwards, defense attorney Maurice Nesson said he wasn't surprised by today's ruling against a defense of moral necessity.
It was a difficult and novel point that hasn't been decided in Virginia, and I understand the ruling and will abide by it.
Do you consider it a setback for your defense?
Well, yes, in a way, but that's the way it goes.
The two defendants reaffirmed their claims that the Surry plant was unsafe, claims specified in a letter the two sent today to the Nuclear Regulatory Commission.
You've alleged that there was dumping of radioactive water in the James River. Has that gone on and is still going on to your knowledge?
Well, since we don't work there now, there's no way to say that, yes, it's still going on.
But it happened while you worked?
Yes, it did.
And do you know about falsification of records?
Yes, we do.
The trial resumes tomorrow morning when both sides will present opening arguments. The prosecution will then present its case, which will include testimony from VEPCO officials and from representatives of Westinghouse, the company which repaired the damaged rods. Defense lawyer Richard Benvenisti says both defendants will testify before the trial is over, probably in 2 or 3 days. Joan Gartland, Area 10 Eyewitness News, Surry. The trial was clearly outlined in this morning's opening arguments. Commonwealth's attorney Gamil Poindexter listed the alleged facts. That on April 27th, the two defendants, William Kirkendall and James Merrill, poured a caustic material on fuel rods at the Surry nuclear plant, causing an estimated $800,000 worth of damage. In his opening argument, defense lawyer Richard Benveniste didn't dispute those facts. He told the jury the question was why the men did what they did. The answer, he said, the defense would show was to bring to the attention of VEPCO what the defendants say are health and safety hazards at the Surry plant. But during the afternoon, the defense had a tough time showing that. Surry plant manager William Stewart was the prosecution's second witness. He testified about the layout of the Surry facility. Under cross-examination, however, Judge Ligon Jones refused to allow defense lawyers to question Stewart about plant safety. The judge frequently admonished defense attorney Maurice Nesson about the relevancy and repetition of his questions, and at one point he threatened the New York lawyer with contempt of court. Neither the defendants nor their lawyers would talk about today's proceedings. It appeared this morning that you all are going to put VEPCO on trial and try and draw the attention away from these two men. Do you think that's correct?
The judge has ordered us not to make any comments to the press, so we're not going to be allowed to comment on that. I think you're going to have to make up your minds from what you saw occur in the courtroom.
Judge Jones made it clear throughout the day that he'll not try VEPCO in his courtroom, despite persistent defense efforts to do just that. Tomorrow, the defense is expected to try again. Joan Gartland, Area 10 Eyewitness News, Surry. William Kirkendall and James Merrill now face 1 felony charge each of damaging electric facilities used to furnish electric service to the public. If convicted of the charge, each could face terms of 2 to 10 years in prison. They also face a misdemeanor charge of entering a building to damage its contents. That carries a sentence of up to 1 year in jail and a $1,000 fine. Earlier today, the jurors watched a copy of this videotape showing VEPCO employees attempting to clean the nuclear fuel assemblies Kirkendall and Merrill say they damaged. VEPCO official Clark Sanger told the jurors the cleanup and repair cost $810,000, and when engineering studies are complete, that cost could rise to over $1 million. The jury also heard from FBI agents who read statements given them by the two defendants, both of whom say they aren't opposed to nuclear power. James Merrill is quoted as saying, "I thought the action would bring to light the serious, unorthodox manner in which Surry is being operated. My only concern was for the safety of the people of Virginia." Another FBI agent quoted Kirkendall as saying, "My motives are not revengeful or malicious. I wanted to show them Surry's not invulnerable to accident, sabotage, or nuclear terrorism. I could have easily caused a deadly radiation leak." Up to this point, Judge Jones has refused to allow defense attorneys to present evidence on the alleged hazards at Surry. But he said yesterday he will allow the defendants themselves to testify about the hazards and about their motivation in damaging the fuel rods. The trial resumes on Monday when both defendants are expected to do just that. Joan Gartland, Area 10 Eyewitness News, Surry. When William Kirkendall and James Merrill arrived at Surry Circuit Court this morning, they were expecting to testify about alleged hazards at the Surry nuclear power plant. Hazards they say they were trying to draw attention to by damaging nuclear fuel assemblies there. But first thing this morning, Judge Ligon-Jones reversed a ruling he made last week and said he wouldn't hear testimony about specific allegations, only on the defendant's state of mind at the time they say they damaged the fuel. The ruling appeared to stun defense attorneys. After a long luncheon recess to regroup, they called Kirkendall to the stand. The 26-year-old former control room operator repeated his earlier claims that conditions he saw at the plant led him to believe the life and safety of plant workers and the public were in danger. He told the jury he hoped the act would shock VEPCO into correcting these conditions. Isle of Wight Commonwealth's attorney Woodrow Crook, who was assisting in the case, tried to challenge Kirkendall's credibility. He brought up the fact that Kirkendall had ended his Navy enlistment early as a conscientious objector. Later, co-defendant James Merrill testified that it was Kirkendall's idea to damage the fuel assemblies. However, he told the jury when Kirkendall approached him, he knew that the act would be the only way to get the company's attention. Everything else he had tried to do, he said, had failed. Late this afternoon, the defense rested. The case is expected to go to the jury tomorrow. 3 of the original charges against Kirkendall and Merrill were dismissed Friday for lack of evidence. They now each face 1 felony charge of damaging an electric generating facility. If convicted, they could each receive from 2 to 10 years in prison. Joan Gartland, Area 10 Eyewitness News, Surry.
The defendants, William Kirkendall and James Merrill, with their wives and attorneys, arrived at Surry Circuit Court shortly before 10 o'clock. In the afternoon's closing arguments, Surry County Commonwealth's attorney Camille Poindexter outlined the alleged crime, that Kirkendall and Merrill poured a caustic substance over fuel rods at the Surry power plant, causing over $800,000 worth of damage. There's no question, she told the jury. They admitted it, and their motives are not worthy of your consideration. They are guilty, she argued, and they must pay the price. Merrill's defense attorney, Maurice Nesson, said motive was important, even though Judge Ligon-Jones had ruled that it was not relevant. He said his client's motive was to save the people of Surry from dangers at the Surry plant, people like the jurors. He also argued a technicality, that since the fuel rods were not in use, they are not part of an electric generating facility the defendants are charged with damaging. He said the prosecution chose the wrong law and asked for acquittal. Kirkendall's attorney, Richard Benveniste, also argued motive. Can there be a better motive, he said, than to help your community? After a final closing by Isle of Wight Commonwealth's attorney Woodrow Crook, the judge sent the 3-man, 9-woman jury to the deliberation room. Earlier in the day, one of the jurors, Mary Etta Chamberlain, was dismissed for an undisclosed reason and was replaced with an alternate. Judge Jones says he'll keep the jury here until they reach a verdict, or midnight, whichever comes first. Joan Gartland, Area 10 Eyewitness News, Surry.
The jury deliberated for 3 hours before returning around 7 o'clock with 2 verdicts of guilty. When polled, each of the 3 men and 9 women on the jury responded yes. They had found the defendants guilty of damaging fuel rods at the Surry nuclear power plant and had sentenced each to the minimum punishment of 2 years in prison. The men could have received up to 10 years. Afterwards, the defendants repeated their claims that they damaged the fuel rods to draw attention to alleged safety and security hazards at the Surry plant. James Merrill said if he had to do it over again, he wouldn't, but says the effects of his action, including a Nuclear Regulatory Commission investigation of Surry, may be worth 2 years in jail.
I feel like as long as anything gets done to make nuclear power safer, that it would be worth it.
Merrill's co-defendant, William Kirkendall, wasn't so sure.
I don't know whether it's been worth it. That remains to be seen. But certainly 2 years of my life is worth many years of this county.
Defense attorneys Maurice Nesson and Richard Benveniste say the jury had sent word to the judge at one point it couldn't reach a verdict. They say it was the defendant's decision that the jury continued deliberations anyway.
Obviously, there was very strong sentiment on the jury for an acquittal altogether. On the basis of the evidence in the case and their confessions, I think it is at least some credit to these individuals and the sincerity of their beliefs in what they did, that the jury gave them the absolute minimum sentence possible under the statute.
The defense says it will appeal the case on the grounds of the evidence it wasn't allowed to introduce. At the request of defense attorneys, Judge Ligon Jones has requested a post-sentence report and says he'll hear that report on November 27th. In the meantime, James Merrill and William Kirkendall remain free on bond. Joan Gartland, Area 10 Eyewitness News, Surry.